Okay, get this. Have you ever heard of a backstage drama so intense, so over the top, that it actually created a whole new type of lawsuit? Well, today we're diving into the absolutely cutthroat world of 19th century London opera. We're talking about a bitter feud between two theater managers over one star soprano that didn't just make headlines, it literally changed the law forever.
And let me tell you, this was not just business. Oh no, it was deeply personal. This quote right here, from the diary of one of our main players, a guy named Frederick Guy, it just sets the stage perfectly, doesn't it? This wasn't some friendly competition. He called his rival a devil incarnate. I mean, that's the kind of raw, unfiltered hatred that fuels the kind of story that doesn't just fizzle out, it ends up in the law books.
All right, so let's set the stage and meet the main players in this whole drama.
So in one corner, you've got Benjamin Lumley, the manager of the super prestigious Her Majesty's Theatre. And in the other corner, we have Frederick Guy running the challenger Covent Garden. By the 1850s, these two were locked in what Lumley himself called a war to the knife. I mean, they were literally trying to crush each other's business. And right in the middle of this epic battle was one person they both knew could make or break them.
And that person, that prize, was Johanna Wagner. You have to understand, she was the talk of Europe, a total rising star, with this magnificent, powerhouse voice and an incredible stage presence. Both Lumley and Gier were convinced that whoever got her would win the opera wars, so they pulled out all the stops. The sources call it vigorous wooing, which is just a fantastic old-fashioned way of saying they were desperately trying to outbid and outcharm each other to get her to sign on the dotted line.
So, it looked like Lumley won the first round. He got her signature on a contract, case closed, right? Wrong. Guy comes back with an even better offer, and Wagner, well, she takes it. She breaks her deal with Lumley. And this right here is the moment where a simple contract dispute goes from being just another lawsuit to a full-blown legal revolution.
Now this put Lumley in a really tough spot, a real legal pickle. See, under the law back then, his only real option was to sue Johanna Wagner for breaking her contract. But here's the thing. Lumley was thinking, wait a minute, the real bad guy here is Guy. He's the one who lured her away on purpose. But there was no legal tool for that. The law just had no answer. At least, not yet.
So what did the court do? They basically created one out of thin air. Seriously, they invented a brand new legal wrong, something we now call tortious interference with contractual relations. And just like that, for the very first time, you could sue a third party, the meddler, for intentionally messing up your contract with someone else. This was a huge deal.
And this comparison here just shows you how massive that shift was. Think about it. The old way was super simple. You had a contract with person A, and they broke it, you sued person A. End of story. That other person, person B, who whispered in their ear and caused all the trouble, totally off the hook, scot-free. But after this case, Lumley v. Guy, everything changed. Now, that third party could be dragged into court and held responsible for the mess they made. So you're probably wondering, how on earth did the judges justify such a massive legal leap? Well, it's kind of wild. They reached way, way back to this really old, almost feudal law that was designed to stop one landowner from poaching another landowner's servants. And then they said, you know what? The relationship between an opera manager and his star soprano, it's kind of like a master and a servant. I know, it sounds crazy to us now. But by saying it was analogous, that it was similar enough, and by painting Guise's actions as malicious, they stretched that ancient rule to fit this very modern contract.
But here's the thing. That legal reasoning, it doesn't tell the whole story. Not even close. To really, truly get why the court made this incredible leap, we have to dig a little deeper and look at the powerful cultural story that was playing out just beneath the surface. And that story, according to a lot of legal scholars, fits perfectly into a classic pattern, the erotic triangle. Now hold on, this isn't necessarily about love or romance. The key to this triangle is that the most important, most intense relationship isn't between the man and the woman. It's the rivalry between the two men. Okay, so in this kind of setup, which was everywhere in Victorian culture, the woman basically becomes a prize. She's the object the men fight over to prove who's top dog, to prove their masculinity. She's not really a participant, she's more like the chessboard on which they play their game. So the crucial thing to get here is that the fight isn't really for her, it's fought through her. And what's so fascinating is that the law already had a bunch of tools for dealing with these triangles. You had torts for seduction, and get this, one called criminal conversation, which was literally a husband suing his wife's lover for damages.
All these laws were about men settling their disputes over women who were, let's be honest, treated basically like property. And in every single one of these cases, there's a common thread. The woman's choice, what she wanted, her consent. Legally, it didn't matter. It was totally irrelevant. Lumley v. Guy just slotted right into this pattern, adding a new line to this very old, very troubling table.
And this right here is the absolute key to understanding the whole thing. By framing the case this way, by fitting it into a story they already knew, the court could see the situation in a very particular light. Johanna Wagner wasn't an independent artist making a smart career move. Nope. In their eyes, she became a piece of quasi-property, a valuable asset being stolen by a competitor. And that, well, that's how they solved the tricky legal problem of her free will. They just ignored it.
And hey, don't just take my word for it. The judge said it himself. In the actual ruling, one of the justices, Justice Earle, spelled it out. He drew a straight line, a direct parallel between Guile luring away Wagner and a man convincing another man's wife to leave him. He basically saw Lumley's right under the contract as being almost the same as a husband's right in his marriage. It's right there in black and white.
So, there you have it. A brand new law is born from a high society opera feud, built on a pretty problematic cultural idea. But the story doesn't end in a London theater. Not by a long shot. In a really dark twist, this legal invention would be exported and used for something far, far more sinister.
Just look at this timeline. It's chilling. In 1853, we get the Lumley v. Guy decision in London. Just 12 years later, the 13th Amendment abolishes slavery in the United States. And what happens almost immediately? Southern states, desperate to find new ways to control the labor of millions of newly freed Black Americans, see this new tort. And they grab it. They adopt this legal tool not for opera singers, but for sharecroppers. And here's how they used it. A white landowner would sue another white landowner for enticing or poaching his black sharecroppers by offering them a better deal. The whole legal fight was between the two white men. The black workers' freedom to choose, to seek a better life, it wasn't even part of the equation. The focus was entirely on the first landowner's supposed right to that person's labor.
The effect was absolutely devastating. It trapped formerly enslaved people in these incredibly exploitative contracts because it made it legally dangerous for any other landowner to offer them a better deal. By labeling them as servants, sound familiar? It's the exact same logic from the Johanna Wagner case. The system choked off their economic freedom. It became, as one historian so powerfully put it, a way of perpetuating slavery under a different name.
Now, you might be thinking, wow, that's some really dark history. And it is. But the thing is, this tort, the one born in that London opera house, is arguably more powerful today than it has ever been. Its stage has just shifted, from the opera house and the plantation to the modern corporate boardroom. $7.5 billion. No, that is not a typo. That's the amount a jury awarded to the oil company Pennzoil back in the 80s after they found that a rival company, Texaco, had interfered with their deal to buy Getty Oil. I mean, think about that journey, from poaching a soprano star in London to blowing up a multi-billion-dollar corporate merger. The scale is different, but the core legal idea, it's exactly the same one.
And all of this brings us to one final, really tricky question. This legal tool, born from a personal grudge shaped by some really outdated ideas about people as property, it forces us to ask a fundamental question about how we do business today. Where exactly is the line between just good, aggressive, healthy competition and an intentional, wrongful injury that the law needs to step in and fix? It's a question that courts, companies, and lawyers are still battling over every single day.